Hi, everyone. This is Stephanie Scarborough. I'm meeting with you today to talk about the elimination of the H4 EAD program, which has been proposed by the Department of Homeland Security. I should mention we'll start right now by talking about what is the H4 EAD program. An H4 is the spouse of an H1B worker. The H4 dependent spousal rule came into effect on May 26, 2015, and it granted historically H4 spouses could not work in the United States. So an L2 spouse, the spouse of an L1A or an L1B, for instance, can get employment authorization to work in the United States. Before May 26, 2015, the spouse of an H1B worker could not work in the United States and could not obtain employment authorization. As of May 26, 2015, USCIS and Department of Homeland Security authorized the H4 spouses to work. And since 2015, H4 spouses have been working. It's really critical that H4 spouses can work because many of us are part of two-income family households and know how difficult it can be, even for a highly specialized worker, to kind of to make ends meet. Furthermore, a lot of the H4 spouses are actually professionals in their own right, and they're able to work and they want to use their skills to benefit the United States economy. So the H4 EAD program has actually been quite successful, and it's helped spouses and it's helped the American economy by providing more highly skilled workers. As I said, many of the H4 spouses are highly skilled in their own right. So what's happened on February 20th is that this Office of Management and Budget has noted that the executive order has been published. The OMB is reviewing right now the rule for removing H4 dependent spouses from the classes of aliens eligible for employment authorization. And this reginfo.gov is a nice resource for tracking these types of alerts, because what happens is the Office of Management and Budget will first review this rule and will basically analyze the rule based on the economic benefit and some of the shortfalls of it, and for consistency. So what happens is once the OMB reviews, then a rule is published in the Federal Register, which will be open for public comment period. So what we have only now is just a notice showing that OMB is reviewing the elimination of the H4 EAD program. And then if we look into the rules, you can see what was proposed previously. The fall of 2017, what was proposed was just literally the extension of the program. Spring of 2018, it was just another review. And then we have most recently in the fall of 2018, although it didn't finalize and materialize, DHS wanted to eliminate the program. So actually, this was they've extended it, and then they want to eliminate the program. So right now we're waiting. When the OMB finalizes its review, you'll see spring of 2019 pop on this OMB website. You'll be able to click it and go into the Federal Register to review the Federal Register announcement. Since H4 EAD has been slated to be terminated, we can expect that this rule will be published probably in the next 45 to 60 days. So for those of you whom this will impact, I would like you to consider that this program is going away and to plan for it, especially the H4 spouses. And, most significantly, the employers who employ these H4 spouses, because it'll be essential that your comments are made whenever the Federal Register is posted. I'll keep you updated on when this Federal Register announcement is posted. You should all be on the lookout. You'll be able to comment on the Federal Register through reginfo.gov, or directly when the Federal Register announcement is made. You'll just be able to search for the rule. I'll provide you with those links whenever they're posted, however. For now, we have just the reg info details that I pointed to earlier. Boom. And this is what we know so far. This will be fairly widely publicized, but I'll keep you all posted. And again, so I would expect the rule to be announced sometime in the next probably 45 to 60 days. The rule will be released, and then there'll be a public comment period, likely at least 30 days public comment period. I will be encouraging all of you to make public comments, especially for those of you that are impacted. I have a lot of employers who we work with who will be heavily impacted by this H4 EAD elimination. And I'll give you an example of where families will be impacted and employers. So the H-1B green card, a green card associated with an H-1B, say from India, for instance, is heavily backlogged with more than 10 years wait for EB2 and EB3 preference categories. So as those workers have to wait 10 years plus, very often what will happen is the primary H-1B beneficiary, sometimes you'll have both spouses on H-1B. One spouse will get a green card application started for themselves, which will preserve their H-1B, potentially for longer periods of time until the green card is available. The H-4 spouse sometimes, though, the spouse will change from H-1B to H-4 because maybe their employer doesn't want to apply for a green card for them. So the H-4 spouse will be left without employment authorization. And under the program where there was H4 EAD, the H-4 spouse could essentially preserve their H-1B time and could go on to H-4, get an employment authorization, maintain usually what is a highly skilled worker position, and work for an employer in the United States legally. And then when their spouse, if their spouse lost their job, for instance, they could actually work and help support the family. And then it wouldn't disrupt the family so much. Or potentially, I've had instances where, because of the circumstances of the green card not being sponsored, for instance, and the individuals on an H-1B, if you're on an H-1B for 6 years, and then your H-4 spouse can get an H-1B, sometimes you can maximize your time in the United States by doing an H-1B for 6 years. Your spouse obtains an H-1B, changes from H-4 to H-1B, and then essentially the roles can flip-flop so that your family could actually be here for 12 years and work to obtain green card sponsorship for one of the spouses, and then wait the 10 years that it takes to get the green card. So it's really beneficial for families from the perspective of just having a second income, a spouse while their children are in school. They don't have to be just idly sitting at home. They can be working and supporting the U.S. economy. And then, finally, just enabling the longevity and the flexibility of being in the U.S. For a longer term. From an employer perspective, what we often see is an employer will have somebody on H-1B, and perhaps the spouse isn't able to find a billable, let's say for an IT position, the spouse can't find a billable contract, but the spouse has maybe HR or human resources experience that they can apply. Sometimes human resources specialists can't qualify for an H-1B or another type of visa. So they may, be well suited for an H-4 EAD where they're able to still support the company, still support the U.S. economy, but some of the rigors of getting counted against an H-1B cap, which is a lottery, aren't required. The expense of hiring an H-4 EAD for an employer is much less, where an H-1B would cost thousands of dollars to hire for a U.S. employer. An H-4 EAD literally is just a verification of employment. So an H-4 EAD really does help those, help employers in the U.S. When U.S. workers aren't available. So it's really critical that the H-4 EAD program not be terminated. So that's the news for today. As of February 20th, 2019, the Office of Management and Budget is reviewing the Department of Homeland Security rule to eliminate the H-4 Employment Authorization Program. Watch, and I'll keep you updated on the pending review status. And when the review is completed, I will provide you with the link and with an update regarding the public comment period. I'll even provide you, if you wish, templates on what kind of public comments and what kind of comments might support the maintenance of the H4 EAD program. Of course, there may also be court action and congressional action. Congress can still act. Congress can codify this law and can produce legislation requiring that H4 EADs be added. Remember that H4 EADs were initially added through a rulemaking authority, and that is kind of lower than a law. So what can happen now is the legislature could act and could propose a law and pass a law stating that H4 spouses have employment eligibility. So that's what we need. We need congressional action. We need this rule to be challenged, public comments to be submitted whenever the public comments come out, and we're probably going to have to resort to court action to try to stop this elimination. However, the present administration, has been very vocal in their desire to eliminate the H4 employment authorization. So I'm sure that they have spent quite a bit of time researching the best method, the fact that the administration is following the proper rulemaking authority, process by going through the OMB and not just doing an executive order to eliminate, for instance. They're following the rulemaking process as required. The fact that they're doing that shows that they've planned this out. It's taken them several months, almost a year now, to get to this point. So expect H4 EAD to be eliminated through this rulemaking process. I don't think the public comments will have a huge impact, but we're going to keep trying. And again, call your congressperson, tell them H4 EAD is important. We'll be posting details on our website and on our blog, scarboroughlaw.com, regarding that. And the important thing is that the H4 employment authorization is important for families, the H1B families, and it's important for the U.S. economy, so we want to support it. Thank you all. I'll keep you posted as changes occur, and best of luck to those H4 spouses.